personal commitment to legal services has perhaps become best known and exemplified by the work he did to establish habeas corpus rights for prisoners at Guantanamo. In 2004, Mr. Oleskey agreed to co-lead a team of attorneys to work on behalf of 6 Guantanamo detainees from Bosnia who had been imprisoned for more than 5 years. Last year, the Supreme Court announced its decision in Boumediene versus Bush, ruling that Guantanamo detainees are entitled to the right of habeas corpus. Following the first ever Guantanamo habeas trial, 5 of those men were immediately freed. Mr. Oleskey's selection as our speaker and honorary degree recipient today is particularly fitting in view of the wonderful work done by this graduating class in hosting and publishing a symposium on detention at Guantanamo. And his work is particularly timely as we watch the current administration and Congress attempt to come to terms with the complexity or mess of closing Guantanamo. But Mr. Oleskey's pro bono work is not limited to this one case. His work is equally extraordinary here in Massachusetts, where he's been a tireless advocate on behalf of low-income citizens. He is past director and president of Greater Boston Legal Services, past director and chairman of the board of the Boston Bar Association Volunteer Lawyers Project, served as chair of the boards at both the Massachusetts Legal Assistance Corporation and of Massachusetts Equal Justice Coalition. Beyond the Commonwealth, he served as the national board and as general counsel to now Legal Defense and Education Fund, where he worked closely with now Northeastern professor of law Martha Davis. He currently chairs the board of directors of PACT, a non-governmental organization that works on sustainable development with programs in Latin America, Africa, and Asia. The list of organizations that have honored Mr. Oleskey for his pro bono work is way too long to read today. But I should also note that his list of accomplishments is not limited to pro bono work. His career at WilmerHale is anchored in a highly successful commercial litigation practice. And he is renowned as a serious, thoughtful, ethical, and effective attorney in all of his work. Steve.
President Ayoun, Dean Spieler, past trustee chair Neil Finnegan, present chair Cy Sternberg, graduates of this great class of 2009, parents, family, and friends, I'm deeply honored to be speaking to you today on this very special occasion for you. Honored because no one truly anticipates such recognition, especially not after President Obama and his recent encounter with Arizona State University, which asked him to speak but withheld an honorary degree on the grounds that he hadn't yet accomplished enough to merit one. As he said last weekend at Notre Dame, he's only 1 for 2 when receiving honorary degrees while giving a graduation speech. Eat your heart out, Mr. President. I'm 1 for 1, and I didn't have to run for president to be here today. I'm also delighted to be speaking to you for a number of very personal reasons. First, because 41 years ago, more or less today, I had to skip my own graduation at New York University Law School to come to Massachusetts to take the bar review course that many of you will soon be taking. Second, my late father-in-law, William Tick, graduated from this great law school in 1942 at a time when inconceivably today you could enter from high school. He had gone to Boston Latin School with only that diploma and then go to night school while working all day to support your family. It took a long time that way, but it saved a mountain of borrowing that I suspect many of you have not been able to avoid. It took him 5 more years, including service in World War II, to launch his legal practice. That fact should give some of you who don't have jobs right now some perspective, if not much comfort. Third, my wife, Professor Judith Tick, has taught here since 1986 in the music department, so coming here today feels like a homecoming to me. Lastly, I have many friends and colleagues who I deeply admire and respect, who are NYU graduates and professors with whom I have worked for many years in one cause or other. I started to list them and then realized there were too many for me to name. But that's an indication of how disproportionately this school's graduates and faculty influence public policy and legal affairs year after year. As other speakers have already said, this shared sense of commitment to something more important than money or power is what draws so many outstanding students like you here and then propels them, as it will you, into the world as agents of change. Now I want to speak to you about something other than the passion that many of you share with me for some form of public service or pro bono work, and the desire you have to use the law and your legal skills to bring about change. I want to give you my perspective on drawing your own roadmap to reach these goals. To begin with, you do need a vision of what you want to do, but equally important, you need to look out for and take advantage of the opportunities that will be all around you now that you've graduated from this fine law school. The road I traveled won't be your road, so I can't draw a map for you. I'm not supposed to. You'll have to draw that map for yourselves. I don't have the answers to the questions about what you should do and when. You have the right and responsibility to live your own questions and find your own road to fulfilling the promise of the degree you receive today. What I can offer is some sense of how I found my road. In it, you can find some markers for yours. My road, as Dean Spieler has said, ultimately led me in 2004 to the representation of 6 men who have been living in Bosnia with their families, working as social workers when the United States had them arrested right after September 11th as suspected terrorists. Our country then had them illegally sent, the term often used as rendered, to Guantanamo, where they were badly mistreated. Answering this call led me and my Wilmer Hill colleagues to 5 years of still ongoing litigation, raising profound legal and political questions, centering on what has been called the molten core of our constitutional protections, the writ of habeas corpus in Article 1 of the Constitution, the founders' commitment that no person subject to our laws could be indefinitely confined without charge or trial at the whim of the executive, whether it was the King of England or the President of the United States. How I arrived at this representation was not happenstance, any more than your presence here today, celebrating your latest achievement, is coincidence. Like my professional career, your initial choice of a job will not determine what you become and accomplish. Whether you join a law firm, teach, become a public defender, go into legal services, business, join a corporation's legal department, or do something totally unrelated to the law, ultimately what you accomplish professionally will be a function of what you choose to do by grasping the opportunities that will be all around you. Let me touch briefly on some of those marker events that have shaped my understanding of the law. This will give you some concrete sense of how you can transform your own opportunities, often as a volunteer, into fulfilling work that will transform and enrich your understanding of what you can accomplish in the world of government, law, and business. For as Eleanor Roosevelt said, and as you will find, action is the antidote to despair. Wanting to make a tangible commitment to civil rights, I received a $300 fellowship for a summer's internship in 1966 after my first year in law school. I went to Mississippi to work as a law student intern to help implement new civil rights legislation enacted under President Johnson. There I saw close up, at roots level on the edge of the Mississippi Delta, how much the power of the law to transform is fundamentally limited by the willingness of government officials to respect and enforce that law, and by whether we as citizens demand accountability from those very officials. We have witnessed that reality over and over again in the last 8 years, of course, but I experienced it myself driving down a lonely stretch of a Mississippi highway late at night that summer, stopped by 5 burly state policemen, arrested on the pretext of reckless driving. I was driven off into the dark countryside in the backseat of a patrol car toward an unknown destination, sitting between 2 of those state policemen, one with a shotgun in one hand and a shotgun shell in the other, which he menacingly tossed up and down beside me. In the events that followed, I experienced for one terrifying hour something of what African Americans in that state had experienced routinely for centuries at that time. Hauled before a justice of the peace holding court in a converted chicken house outside his rural farmhouse, deep in the Mississippi backcountry, only 2 summers after 3 young men named Schwerner, Cheney, and Goodman had been found buried under a hastily erected dam, shot to death. I regretted deeply that I had ignored the basic warning I'd been given in my training seminar, never be out alone at night in rural Mississippi. Yet in what happened that night, I also saw the extraordinary reach of the Constitution when that rural justice of the peace, roused from his bed, appeared in his nightclothes to appear at my hastily convened summary trial. After he called his court to order the 5 state policemen and myself and heard the charges, he asked me to respond. With what I hope was a calm tone, I said that I wanted to call a lawyer. After what seemed an eternity to me, but was probably only 15 to 20 seconds, he amazingly agreed. What he said to those 5 state policemen is etched into my memory indelibly. Boys, the Supreme Court says he gets 1 call to a lawyer. I made that call to the only lawyer whose phone number I had, the same lawyer who had warned me in my training session never to be in the situation I was in. His chilling counsel to me over the telephone was this: "We can't help you out there tonight. It's too dangerous. Plead guilty, pay the fine, hope you have enough money, and get out of there alive. If you spend the night there, you won't be found in the morning by us or anybody." That Supreme Court decision, which was my literal lifeline that night 46 years ago, was the 1963 decision of Haynes against the state of Washington, where Justice Goldberg from the majority wrote that it was inherently coercive to hold someone in custody for questioning without giving them the opportunity to call a lawyer. The power of law to affect my life as well as that of others could not have been brought home to me more forcefully. Similarly, once I began my career here in Boston in private practice, in a decade of volunteer service on the board of my downtown civic association, I learned how determined citizen groups working collectively outside the formal political structure could stop a planned massive high-rise development called Park Plaza that would have destroyed the public garden and common. We citizens stopped that project after a long and ferocious battle because the then very young, very smart first-term Massachusetts state representative named Barney Frank, who was also a law student at that time, discovered and successfully invoked the obscure state statute that required a 2/3 vote of the entire legislature to take dedicated public park space for some other purpose. The power of lawyers to take law and use it for the public good was graphically demonstrated to me in that instance. In electing as a first-year lawyer to spend 1 lunch a month at the Massachusetts Civil Liberties Union, I opened the door to pro bono representation of a woman named Lucretia Richardson, who had been denied a job as a social worker in the Commonwealth because she could not offend her conscience by taking the state employee's loyalty oath. 18 months later, when the more experienced associate who was leading the case left the firm, I found myself at age 29 at a lectern in front of the United States Supreme Court, in front of Chief Justice Berger and Justices William O. Douglas, Harry Blackmun, Byron White, Potter Stewart, William Brennan, and the immortal Thurgood Marshall. I was not even through the obligatory introduction. It's on a card in front of you when you stand up, as I am here, which you are to invoke as you begin your Supreme Court argument. "Mr. Chief Justice, and may it please the court." The Chief Justice immediately interrupted me and said, "Mr. Oleskey, tell me why the oath your client claims offends her constitutionally is any different than the oath you took to become a member of the bar of this court, which allows you to appear here today." When I answered that I was still too young to be a member of the bar of the Supreme Court at age 29, had therefore never taken the oath and did not know it, he crisply responded with a smile that cut through me like a dagger. "That's okay, I have it right here. I'm going to read it and then please answer my question." He read it, I gulped, and did my best in the 5 seconds I had to respond about an oath I heard for the first time. With that, the court and I were off on an exhilarating Nantucket sleigh ride of 30 minutes of solid questions and answers. As you will find when your time comes in similar situations, the exchange like that in your first appellate argument composes your mind very rapidly and puts future, otherwise traumatic, professional moments such as your first jury opening in a much more nuanced and relaxed context. Well, the court ultimately decided against my client by a vote of 4-3. The controversy surrounding that case led the Massachusetts legislature to repeal that oath. That was when I learned, as you will, that there are multiple advocacy routes to success when appearing in public disputes, and that a good advocate needs to consider and pursue as many avenues as possible simultaneously. That's certainly the lesson of our representation in the Guantanamo case. With these experiences and others like them, including several years in public service in the Massachusetts Attorney General's office, it was almost inevitable in late 2004 when I noticed an internal email asking if anyone wanted to represent Guantanamo detainees that I immediately pressed reply and typed yes after my equally committed partner, Rob Kirsch, agreed this seemed likely to be a two-partner case, especially as neither one of us knew anything about habeas corpus. He's an environmental lawyer, I'm a general civil litigator. A mere 36 hours later, our partners had agreed the firm would take on what has become a historic representation. That representation still continues after 5 years, and in legal services, which if billed at our customary rates would approximate $20 million, involve not two partners, but 9, 20 younger lawyers, and events beyond anything we could have imagined at that time. That case, Boumediene v. Bush, has brought us 2 Court of Appeals arguments, a Supreme Court argument, extensive work lobbying Congress, the first Guantanamo habeas trial last fall, an FOIA suit, another avenue to advocacy in a case like this, a European Court of Human Rights suit against Bosnia, yet another avenue to attack the same problem, and an unending array of diplomatic initiatives in Europe and the United States, together with negotiations with 3 foreign governments, none of which either law school or your practice suits you for, but you learn how to do it when you need to do it. Our work is not yet done. 2 of the men still remain in Guantanamo. Along the way, I visited that awful place 20 times to counsel our clients. That place, if you do not know it, is a tiny 40-square-mile patch in the coast of Cuba where lumbering, overweight iguanas are protected by federal law, but as we've all learned to our shame, men are not, where they're routinely exposed to torture on the exquisitely detailed orders and authorization of our very highest officials, acting with written assurances provided by clever and experienced lawyers in our Justice Department. Let me give you one example of how wary our clients were after their brutal mistreatment, which continued for 3 years before we arrived. I met with our client Saber Lakmar on the first trip. After the introduction and preliminary chit-chat through the Arabic interpreters who we retain and bring with us, Saber suddenly took out a piece of blank paper, put it in front of me, took a pen and said, "Sign your name." I did so. He then turned the paper over and I saw that on the other side was my signed letter of introduction to him, explaining who I was and that I was coming to be his counsel. He said, "The signatures don't match. How do I know that you are who you say you are?" I realized immediately what had happened. I had been out of the office, and one of my younger colleagues had signed my signature to the letter that I had drafted and approved that Saber had. I explained it to him. He ultimately accepted the explanation, but not after telling me on many occasions about the many interrogators who had appeared with him pretending to be lawyers or others who wanted to help him in the years before we had arrived. Later, in a letter from our client Mustafa Adadir, I grasped the understandable depths of their utter lack of faith in achieving any justice whatsoever from the American justice system, in which I spent my professional life as an advocate. Mustafa wrote roughly the following on one despairing day several years ago. "Dear Steve, I want to thank you and Rob and your colleagues for fighting so hard in our courts to help us. You're very good lawyers, we see, and you're doing very well what you're trained to do. But I understand something you do not about my case. It is now and has always been entirely political. Nothing you do in your American courts can change that or help us. But we appreciate your efforts. Please don't stop. You do what you need to do." I've often reflected back on Mustafa's letter, especially last November 20, when the federal judge who had just heard the first Guantanamo habeas cases, a judge who was an appointee of President George Bush and had been a member of the Federalist Society, read in a silent, expectant courtroom his decision remarkably granting habeas corpus to Mustafa and 4 of our 5 other clients, while they listened on an open phone line that had been established so they could sit in the prison in Guantanamo in chains, but still hear the decision. That judge ended with a unique and impromptu plea to the president, who had appointed him not to appeal that decision. Quote, in light of the evidence that exists about these men who have been imprisoned without charge or trial for 7 years, and the evidence that does and does not exist. Then this week, when both houses of Congress panicked deplorably and demonized everyone in Guantanamo as a terrorist who should be kept there even if a federal judge had ordered them freed after illegal confinement, and the Congress refused the money the president sought to shut our own despicable version of Devil's Island, I realized that Mustafa was also right. In some profound sense, these cases were, as he wrote, all political as well as all legal. Well, my experiences may seem remote as you graduate in the teeth of what we've all been lamenting here correctly as the worst economic climate in at least 50 years. They are not so remote. You will have your own opportunities. Like the formative decade of the 60s for my generation of lawyers, you are also going to find the next decade a time of great opportunity, excitement, and fulfillment. Scott and the other speakers are right. You too will find ways to tap into these opportunities to affirm the role of law, to enrich your personal and professional lives by working to find what you find must be changed. Building on the foundation of the superb education you've just completed here, stay true to your own vision. The vision of what you want your life to be, and follow the opportunities that assuredly await you. All of us in this room, and many who are not here, are confident that you will do exactly that. Good luck. I look forward to reading about your commitments to your cases and causes in the years ahead.